Thank you so much, Tom. And welcome, everybody. We've had a great time preparing for this session, so hopefully you'll have a great time listening to it. And I'm very excited. I hope you were able to see the fireworks last night for our 50th anniversary. Really cool to see. Wasn't that fun? So thank you for being here to celebrate with us, and many thanks to Tom for being our fearless leader, not just this year, but during the 2 years when we were all in the darkness and appearing virtually, and it's very nice to be back here in person. So I'm delighted to introduce to you Gurbir Grewal, who is to my immediate left. Gurbir has been serving as the SEC's Director of Enforcement, leading the thousands of enforcement professionals in protecting securities investors. He came to the commission after serving as the Attorney General of the state of New Jersey. Earlier, he was a prosecutor as the chief of the Economic Crimes Unit in the New Jersey's U.S. Attorney's Office, and in the Business and Securities Fraud Unit for the Eastern District of New York. So he has extensive experience focusing on the things that we focus on. He also worked in private practice back in the day, so he has that perspective and brings all of that to his work. Michael Conley, to his left, has also appeared on this program before. Michael is the solicitor of the Securities and Exchange Commission. He has served in that position since October of 2015, and he also has served as acting general counsel. As solicitor, he oversees the agency's appellate litigation and bankruptcy group, and you'll hear more about that group's work as well as the work other parts of the Office of General Counsel do today. He joined the commission in 2000 in the appellate group, and before coming to the SEC, he also worked in private practice. So as we're getting ready, the audience has changed a little bit over the last couple of days, and I also would like for us to get a sense of kind of who you are and what you care about. So I'd like for you, if you don't mind, please, to raise your hand if you are currently working in-house directly for a company of some kind. Okay, great, thank you. How about in private practice, working for a law firm? So that looks about even. How about people in government service, currently employed by the government in some capacity? A few. Excellent. Excellent. Okay, we want to make sure we talk about the things that you care about, so here are some of the topics. We have a lot planned, but I want to make sure we don't miss something if it's something that you care about. How many of you are interested in individual liability versus entity liability, and what individuals can be at risk for being liable for? Is that something you're interested in? Okay. Public company issues like disclosure issues and what the enforcement division thinks about issues like that. Okay, there we are. Cooperation credit, what you do during an investigation that can matter to the outcome. Yep, okay. Regulated entity issues, do we have broker-dealers, exchanges, a little bit of that. Probably not the primary focus today, but you'll pick up a fair amount, and we can talk after if you'd like. How about digital assets and crypto? People interested in that topic? A little bit, okay. And lawyer liability, when lawyers can get in trouble. Okay, all right. Well, we'll talk a little about that today, and I'm pleased to say right after the break, after our session, the ethics people will be up here, and they can help you too. So with that, why don't we get started? And Gurbir, can you kind of give us a little bit of focus on what you're thinking about in 2023? Where are your priorities going this year?
Sure. Dixie, thanks for the very kind introduction, and thanks to the Institute for the invitation to be here with you this morning. This does not suck to be out in San Diego after leaving dreary New Jersey to fly over here last night. And let me just also start with a disclaimer on behalf of both Michael and me that our views this morning represent our own views and not those of the commission, the commissioners, or the staff. So about priorities for this fiscal year, 2023. I think to put it very simply, our number one priority in the enforcement division is to help the commission achieve its three-part mission of protecting investors, facilitating capital formation, ensuring the fair, orderly, and efficient operation of our markets. And the way we do that, and the way we're going to do it this year, is by making sure that we're using all of our resources, leveraging them wisely to make sure that we are that cop on the beat for the commission, that we are out there protecting against known traditional risks, the financial fraud, the issuer disclosure cases, the insider trading cases, the Ponzi schemes, all of what is really just the bread and butter, things that we are reacting to either through referrals from folks in this crowd or from other regulators or from our exams division. And then it's also balancing that with against emerging risks. You know, what are we seeing? Where are the risk areas? And right now, given the volatility in the crypto markets, that is a top priority for us. The chair has spoken extensively about the runway getting shorter because there are a lot of non-compliant actors out there, for them to come in and register with us, whether they're exchanges, whether they're intermediaries, whether they're issuers in this space. Because as we've all seen in recent news cycles, a lot of retail investors are being hurt in the fallout from a number of crises. So that is going to be a top priority for us this year, has been over the last fiscal year as well. And another area where we're seeing a lot of volatility and will be a priority area for us this year and was last year as well is in the private fund space. Maybe not a topic that was on our list this morning, but you know, I think it's the Warren Buffett expression that it's when the tide goes out, you see who's been swimming naked, and I suppose the corollary to that is a rising tide hides a lot of fraud. And as this tide is going out, we've seen a lot of fraud in the private fund space, which is really an opaque space, and as things are getting a little bit more difficult, we're getting more and more involved in that particular space, whether through exams referrals or through other referrals. So I think that's another priority area for this year as well. And the final one sort of captures things that are important to investors now, and that's ESG. Climate issues are top of mind for investors, and we're seeing a lot of cases where, whether they're advisors who are marketing particular funds in an inaccurate way, in a misleading way, we're seeing issuers speaking on climate issues in a way that's inaccurate. There's material misstatements around ESG policies, things of that nature. We brought cases, and we continue to see risk there. Again, an emerging area because it's important to investors right now, and we're seeing a lot of issues around those types of disclosures. That's sort of the what of what we're going to be looking at this particular fiscal year. I would talk a little bit about the how we sort of approach our work in the division. And I think this is relevant to all of those in this audience who work at public companies. I firmly believe, and I've spoken about it over the last 18 months as director, that there's been a decline in trust in institutions. There's been a decline in trust in large corporations, in financial institutions, in our markets, in government as well. And sometimes that trust, that lack of trust, is tied to a belief by some out there that corporate wrongdoers, individuals, are not being held appropriately accountable. That there are in fact two sets of rules, one for those who are powerful and another for everybody else. And that's bad for all of us in this room, because if folks don't trust our markets to work efficiently, if folks don't trust large companies out there, they're not going to invest their hard-earned money in those markets. And that hurts everybody who's playing by the rules. And so an animating principle for us in the enforcement division has been, since day one for me, working to restore that trust by being really robust in our enforcement efforts, being robust in the remedies that we seek, and trying to create with each of you in this audience a culture of proactive compliance, realizing we can't do this alone. And on that first piece, on robust enforcement, that means working with a sense of urgency, bringing our cases more quickly, because the longer our cases take, the more that mistrust grows. Because if somebody reads in the paper today about some wrongdoing, about a self-report, and they don't hear about the resolution for a period of years, they're wondering in the interim, what's going on? Are people being held accountable? And on the remedy side, we really want to send a deterrent message using all the remedies at our disposal. And then on the final piece, which I hope we get into today, is how can we all work together to help foster that trust, to help us do our jobs more effectively so we can help help each of you do your jobs more effectively, because it is really a shared mission. We're not there to play a game of gotcha with each of you. We would much rather be in the position where we're not bringing more and more cases each year, that we're using our resources in a way where conduct is getting better, people are playing within the chalk lines, and that things are operating better for all of us.
Well, thank you for that. And the good news is these folks have been here for days now, learning old rules, new rules, application of rules, what best practices are, and getting ready to go back out there and be in the trenches to enhance compliance with the federal securities laws. So this is the right audience for you to connect on that with. So Michael, I think your job is fascinating, but I don't understand all of it. Can you give us kind of an overview of what you do and what the General Counsel's office does as it relates to public companies and when they intersect with the Commission?
Sure. I will say that when I think about my work in particular, I think about it probably falling into broadly 4 buckets. I mean, part of it is the stuff that comes directly from Gerbir and his folks, which is we would defend appeals that are taken in civil enforcement actions that are filed in federal district court and in litigated administrative proceedings. And that's a big part of our work. It has been historically. But something else that the Commission does is the Commission enters orders of various sorts, and we will also defend those orders from challenges that are made in the courts of appeals. And they come, probably the things that would be most familiar to people are 2 types. One is orders in disciplinary proceedings from self-regulatory organizations like FINRA, say broker-dealer disciplinary proceedings. And the other, which has become a big part of our work, is challenges to Commission rules, which the Commission adopts through orders. And so there's a fair amount. And so there is one of the ways I think that we would intersect with things that affect public companies directly. Because if there are challenges to rules, we would be defending those. And the third thing that we spend our time with is in preparing and filing amicus briefs for the Commission, which are filed in a variety of different courts. And those are cases in which the Commission is not itself a party, but there's an interest in the case. Typically, they would be, say, private securities cases that where the statutory provisions are provisions that the Commission also applies in its own cases, or they might be exclusively in private actions, but the Commission has a responsibility for promulgating rules that relate to those actions. And the last thing that we do is sort of less formal, but also, I mean, critically important in the Office of the General Counsel is that we serve an advisory role for the Commission. We advise the commissioners in their offices. We advise the various divisions and offices throughout the agency. And that's something that we're doing all the time. Every day, we're on the phone with people. We also have more sort of formalized advisory relationship. And so that's kind of my job, I think, in a nutshell. And in terms of expectations for the coming year, it's a little bit different than Gerbir, because we sort of get what comes to us in probably the best way of thinking about it. We know that there's a lot of action that's out there that continues, in particular, something I'll talk about a little bit later in our discussion this morning, but the decision of the Supreme Court in the Liu case a couple of years ago, which deals with disgorgement, which is a remedy that the Commission can get in cases that it files in federal district court. And that decision really looked at disgorgement and said, as an original matter, can the Commission continue to get it? And if so, what are some of the limitations on the Commission's ability to seek disgorgement? And those issues are really being played out now in the lower courts, and we're very much involved in addressing those. And as I said, I think we'll talk about that a little bit more later.
Yeah, we will, and the disgorgement issue is an interesting one because it is a giving back of gains that someone got due to conduct they shouldn't have been doing in the first place. So they never should have gotten those gains. Those are ill-gotten gains. And discussing what those are and what the volume of it is and really how to identify it. In addition to the court parameters, there are economic parameters on that too.
Sure.
So those are a lot of the discussions that people have in the trenches these days. Michael, before we leave you, I know it's not part of your focus in the Office of General Counsel, but the OGC also has a voice in lawyer discipline. Can you give just a couple of words about that? And I know that's actually separate from the Enforcement Division's role.
It is. Within our office, one of the subparts of our office is what we refer to as the General Litigation and Administrative Practices Group. And one of the functions that that group has is overseeing what we refer to as our Rule 102E program. And that is the program that relates to lawyer conduct and misconduct, and in particular for lawyers who practice before the commission. So we have lawyers in that group who, and often this arises actually sometimes out of enforcement actions. You'll see that there's certain conduct and misconduct that's been engaged in by lawyers who are representing the folks, say, who ultimately wind up getting into trouble. And so those are administrative proceedings. There are rules that govern them. And it's something, as I said, that the litigation group within the general litigation part of our office handles.
And it can be startling to think your conduct would be, in the middle of an enforcement review, and then suddenly there you are talking to the General Counsel's office and more people who want to ask you about your conduct. So it can be interesting. So it's a good thing to have a heads up about and know that happens. Again, the ethics panel is next, so you'll get more information about lawyers there. So let's transition to some of the topics that you gave some highlights on, Gerbir. And you mentioned length of investigations. I have had investigations ranging from 11 business days, which I think everybody felt was a big victory to start and finish in that time period. That's not the norm, though. I have some that go 4, 5, or more years, which I feel like really is not my fault because we're busy trying to help get things resolved, and I'm sure the staff feels the same way. So do you have any kind of big picture on how long it takes and what we can do on the outside to help things move more quickly, because everybody is happy when they don't have to work with me anymore?
Well, it shouldn't take 5 years, right? Our goal, as I mentioned at the outset, is to move as efficiently and as quickly as possible for some of the reasons that I mentioned a moment ago. But faster, more efficient investigations are better for investors, they're better for issuers, they're better for firms under investigation, they're better for us in getting fresher evidence to the hands of a jury. Delay may allow fraudsters to dissipate assets. Delay in a disclosure investigation, for example, may slow the market or may delay the market from getting accurate information for too long. A delay in an advisor case about a conflict of interest may not allow a client to move to a different advisor, because if they had that information, they might do that. And protracted investigations, I've seen this from my time as a prosecutor and in my time in private practice, has a profound effect on those under investigation. I mean, it is a terrible burden to bear, and so if we're not going to make a recommendation, we need to get to that point more quickly. So on our part, we're doing everything possible to tighten our processes, to tighten our review times in the front office, working with our colleagues in the other divisions, because we're not out on an island. Enforcement is not going rogue and making their own decisions on what to recommend to a commission. There is a very detailed, in-depth process which takes a lot of time to get it right. We consult with all of our other divisions. When we're working on a disclosure case, we consult with our colleagues that you heard from yesterday in Corp Fin to make sure that we're reading rules correctly, to make sure that we're getting things right. We consult with Michael and his team extensively before we make that recommendation to the commission. So we're trying to tighten those timelines on the enforcement side to move things more quickly. But I will say, Dixie, a tremendous amount of delay, and not in the cases that you're handling, but in the cases that other lawyers are handling, does come from gamesmanship from defense counsel. We have defense counsel who are expert, and I could tell you before a team comes to me if they've flagged an issue with document productions, who those attorneys are. Because more often than not, they're repeat players, slow-rolling document productions, dumping terabytes and terabytes of information on us, gamesmanship around privilege issues. We believe in the sanctity of the attorney-client privilege, but we're not going to just stand back because the lawyers told us something's privileged. We need to see privilege logs. There has to be something behind that, and not just a delay tool. And so, it happens on both sides. We're trying to tighten it on our side. We're hoping defense counsel and the companies that they represent help us, because again, it's a shared effort to get to the right place, whether that's a recommendation or making the recommendation not to proceed in a particular matter. And so where you can help is by helping us identify key documents earlier, by making witnesses available earlier. In some cases, we have witnesses overseas during the pandemic. We had some difficulty with translations and things of that nature. Companies who exhibited great cooperation helped us secure translations, helped us get to those witnesses in an efficient manner. And that helped move things to resolution more quickly, which again benefited everyone involved in the enforcement process.
Well, a lot of people I know on inside and outside the agency try to do those things. They don't always accomplish the speed that we want, but are there guidelines internally on how long you want people to be spending in each phase of the investigations, or does that also vary?
It varies, because I imagine the 5-year investigations that you're talking about are sometimes FCPA investigations where we're collecting evidence abroad, where there are overseas regulators involved, when there's other government agencies involved, when we're trying to coordinate resolutions across government agencies. So there's no hard and fast rule. The goal is to move things as efficiently as possible. On average, we were over, I think, 24 months. When I got to this role, I think we're creeping to that 20-month range as our average time from opening an investigation to concluding an investigation.
Because my 11-day thing really helped on that.
And then the 5-year thing didn't help.
Right, that's true. That's true.
So, again, that is the message to the staff. The staff is responded and have been moving things more quickly. We brought more actions last fiscal year than the prior fiscal year. We've secured more in remedies, as we'll probably talk about, in the last fiscal year than the prior fiscal year. And we did it all while in a remote posture, right? We're not fully returned to office yet. We're a voluntary return to office right now.
When is everybody going to be back?
That's a great question. We have been contending with a lot of labor issues. A number of our employee groups are represented by unions, and so I can't get into the conversations that are happening there. So there are a lot of challenges that folks are working through to try to get to a place where we could bring back folks safely. I think the nature of work has changed over the last number of years for all of us, and so we're trying to figure out how to accommodate for that as well. When we had, a very not a permissive telework policy, what does that look like when we come back? And so right now, supervisors are voluntary or mandatory return to work for a number of days each pay period, and I expect the rest of the staff to come back to return to work after these labor issues are resolved. But people are in the office. We are having in-person meetings, maybe not at the same pace as in the private sector, but a lot of that is getting back to the new normal now.
If I could just one comment on that, because I was somebody who, before the pandemic, really never teleworked. I was always in the office, and I had my doubts at the outset that we would be able to accomplish what we do, in a remote posture, which became necessary, obviously, for health reasons. But one of the things I really do want to say is how pleased I ultimately was, with the ability that the staff has had, under not ideal conditions, to be able to complete our work. It's not the same. as everybody knows, but people have worked extraordinarily hard and I think have done a great job and really haven't missed a beat in terms of things that we need to do in order to carry out our mission. So.
I think there are some good things. I mean, the pandemic obviously was tragic for many people and for a lot of reasons. I always try to look for silver linings, even when things are difficult. And I really have had a lot more Zoom-type, face-to-face meetings with staff members over the last couple of years than would have been the case if we were operating regular way. So I feel like the relationships with the staff can be stronger in this environment because nobody has to travel. You just hop on and you talk and you can see each other. And I think that's really helpful. It's interesting though for witnesses how to do the best we can to take care of them when they're appearing before you guys in an enforcement context. And that really, to me, there are situations where a remote testimony session makes sense, and it makes it easier for everybody and less stressful in some ways for the witness who's going through something they only hopefully have to do once in their lifetime. But there also are some times when witnesses really need to be there so that the staff can make a really excellent credibility assessment. So I'm kind of glad we're doing a little bit of getting back to work because sometimes those meetings are really more important than others, I think. So penalties. We saw in the fiscal year 2022 report, which I think is in your materials, that it was a record-breaking year for the SEC with its remedies, over $6 billion in civil penalties, disgorgement, and prejudgment interest. And that's a lot of money for, I know you have a lot of people, but still not a very big staff to have achieved that kind of result. And that was not double, but kind of almost double what it was the prior year. I know that there was a string of cases involving large institutions with regulatory obligations which is probably not the main thing that these folks think about day to day, because most of the people here aren't dealing with regulated entities. But there are record-keeping requirements for things like communications with clients. And the big banks, I guess, all got caught up in off-channel communication challenges. That took up a lot of these dollars, I know. But when you look at the program overall, I know it's hard to back out some, but in the public company space, how are you feeling about what the level of penalties are and how things are moving along in the penalty and monetary area?
Sure. Remedies, including penalties, are one of our most important tools to encourage compliance with the securities laws. And when I talk about, our penalties need to be robust, what I mean is they have to be more than the cost of doing business. We're not trying to seek in our resolutions more than we're allowed to seek when we consult the statutory tiers, when we consult commission guidance, when we consult precedent, when we consult comparable resolutions, but we want to seek penalties, and this is the message to the staff, that have a specific deterrent effect on the particular firm or entity we're dealing with, but also a general deterrence effect. And I'll tell you where this originated from was in a meeting that I had very early on in my tenure in this role. And a really well-established practitioner and team came in to negotiate a resolution and to support the penalty that they were advocating for in these conversations. They probably had a first-year associate spend maybe 3 or 4 weeks scouring our website, looking at every possible comp in the particular space and for the violation we were looking at, and presented us with a 3 or 4 page appendix and saying, hey, look, you have never gone above X. Why do you want 3X from us? And my response to that was, well, you've just shown me why we need 3X, because we've had 20 or 30 years of similar violations across the industry, and the behaviors are not changing. we're not getting compliance in these particular cases. And so that's part of the decision-making that goes into this. We look at the conduct at hand, we look at the statutory tiers, we look at all these other factors to make sure we're crafting that penalty that has specific and general deterrence. On the books and records cases, that's a perfect example. Prior to these particular resolutions, the previous highs had been, I think, in the 10 or 15, maybe $30 million range. But we saw persistent violations of broker-dealers not maintaining books and records as they're required to do. People were going to WhatsApp channels to talk about deals. They were going to personal emails and personal text groups. And the people who were charged with ensuring compliance there were looking the other way. Sometimes they were involved in the decision-making to go off-channel. And so those prior penalties didn't shape positive behaviors. And so we went out with a very large penalty. The CFTC had a parallel case, and that sent a strong message. But we knew that the particular entity we were dealing with wasn't alone in this violation, so we cast a broad net, and we did a sweep in the space, and we saw that everyone at big broker-dealers that we looked at had a similar problem. Now, those resolutions were at over $1 billion collectively with, I think it was 16 broker-dealers and 1 investment advisor. I don't expect, as more and more people now come in to self-report, when they self-remediate, when they come to us and say, you know what, we had a similar issue, that we're going to be in that same space, because those penalties, as we've seen, are having a deterrent effect as people are coming in to self-report, and we're reflecting that in the resolutions that we're negotiating with those particular entities. And so I think that's the way in which I view penalties and how we should be crafting them, because folks have taken notice and they're coming within the chalk lines and playing within the rule sets. And again, that's better for all of us who are operating in this space, and it's better for that public trust that I spoke about earlier.
And on the off-channel stuff, I know that most public companies don't have that same record-keeping requirement that the big broker-dealers do, but they do have obligations to hold on to material once there's an enforcement investigation or once there's civil litigation. So reading those cases may not be at the top of your list, but reading 1 or 2 will probably wake you up to what could be going on in your business. Even if you have bring your own device policies, it's something to watch out for.
Yeah, and just on that point, again, I talked about robust enforcement, robust penalties, but we do have to have this proactive compliance. And to that to me means that each of you who are in-house are engaged in your businesses, that you're understanding where the risks are, that you're also educating yourselves about what's going on, not just in your business lines, in your industry, but more broadly at regulators like ours, because the Commission is being very intentional in its public orders to identify the scope of the wrongdoing here, what we're seeing in how messaging has changed over the last number of years, particularly during the pandemic. And you need to use those orders as a teaching moment to see where the risks are in your business. How are folks in your industries communicating? Do we have the right record retention, keeping requirements and tools? And are we casting a wide net when we're responding to a subpoena to make sure we're going to all these custodians and getting all the relevant communications when we're responding to a government inquiry or in private litigation to a litigation hold? Because things have changed in ephemeral messaging, which we haven't even talked about, Signal and other applications are being used out there. And more often than not, they're used to engage in wrongdoing, to hide particular communications. So I'd encourage each of you to look at those orders to see how they affect your businesses and then execute, right? We've seen plenty of cases. In those cases, they had great compliance policies, but no one executed on them. So it's not just about having the compliance policy, it's about implementing it, it's about executing and making sure people are abiding by it.
So they really will look at your policies and find out if the people who are supposed to be following those policies are following the policies. So if you haven't looked at internal policies for a while, it's a good thing to take off the shelf and take a look at, because they'll take it word for word. Sometimes your cases are brand new and not situations where for years you've been making statements and feel like you need to ratchet things up. An example of that is the recent case against McDonald's and the former CEO of McDonald's. It was interesting for a number of reasons. There was no penalty for the company. The case really focused on a disclosure that McDonald's did not make in the proxy context. McDonald's had done an internal investigation, dismissed the CEO, or he left the company. The commission found that McDonald's had discretion over the circumstances of him leaving the company and whether he was to get severance and how much that severance was, and that McDonald's, in exercising that discretion, didn't, as required by the proxy rules according to the SEC, didn't disclose the discretion that they had in dismissing him. I hadn't seen another case like that, especially in looking at disclosures through proxies relating to disciplinary actions involving the departure of an executive. And I know you can't talk about specific situations, but that all settled. And the CEO separately was charged with 10b-5 fraud for his statements. And that was a new kind of case. I think everybody here, well, do you have anything you can tell us about the proxy rules and how the commission is looking at proxy rules in situations like that?
So I'll speak a little bit more broadly because, when we talk about first of their kind cases, we're not making it up as we go. OGC will not let us do that. The other divisions won't let us do that. You might have first of their kind cases, but they don't involve new principles or new laws. They involve well-established rules and regulations, and we're implementing them maybe to a different fact pattern or applying them to a different fact pattern. But the linchpin of that case and other sort of disclosure cases that you might think maybe far afield from the traditional disclosure cases about financial statements and things like that, and financial reporting, is materiality. Is this relevant to an investor in making an investment decision? And in that particular case, it's highly relevant when you don't truthfully speak on executive compensation. You don't truthfully speak about the discretion you exercise when your own standards of business conduct said that the particular facts of that case would give rise to a for-cause termination, and you're not making clear that you exercise your discretion to avoid abiding by those standards and to terminating that CEO for cause, and instead are putting forward this executive compensation package, which eventually they sued to get back because the CEO had made additional misstatements about his conduct in public statements and press releases that McDonald's had issued at or around the time of his termination. So I don't think, lying about something that's material, including the reasons and causes for the termination of your CEO and the compensation they're receiving, is far afield from the other types of disclosure cases we've brought.
Just having been involved in situations like that, my guess is that the people crafting the disclosure in the proxy weren't thinking that they were lying about it. But it's an important case to read if you haven't seen it yet. It happened just a couple of months ago, right? Yeah.
And Dixie, if I could just make building a little bit on what Gerbir had mentioned about these first of their kind cases, and the scrutiny that's given to these at the agency is really intense. And I think about the involvement that OGC has with the Division of Enforcement, and it really falls into two buckets broadly again, where you have formal type involvement, which the office does have. Every enforcement action, ultimately goes to the commission, but it's preceded by, many layers of review. And one of those layers of review occurs in the Office of the General Counsel, where action memos are prepared, and the legal policy group within our office does a substantial review to kind of as an institutional check on what's going on in each of these cases, and to ensure both consistency with the law and also consistency with what the commission has done previously. And so there is that, and there's a lot of back and forth that happens between our office and the Division of Enforcement. And that's extremely important, I think. It really does sort of confirm what Gerbir was saying, which is that nothing happens just in a sort of slapdash way. There's very serious scrutiny that's given to whether the particular action that's being recommended is fully consistent with not only the agency's mission, but the legal constraints under which we operate.
And it does help, it does. There often are situations where the law emerges at a certain point and it causes a whole different dialogue than you expected on the outside or on the inside. But it's helpful to keep all of us going in the right direction.
And again, like for those of you who are in-house, we are very intentional. The Commission's very intentional in its public statements, in its orders, in how they're communicating about violations. You've got to look at them. You've got to be on top of what's coming out, because that's the only way in which we could speak more broadly to markets and to issuers. And there's a lot in our public documents, which could help you better do your jobs.
Another kind of public document, Michael, could you talk a little bit about the amicus program? I know at various times the Commission seems really active in filing amicus briefs, and at other times they aren't getting, if they're happening, they aren't getting the kind of news that they do in other time periods. I know the website posts the procedure that you're supposed to follow to actually get the attention of the staff and bring them in on a civil litigation matter where you think the SEC might have an interest. What can you tell people who are in the middle of civil litigation and think that maybe the SEC could be useful as an amicus in their case?
It's a really good question, Dixie, and I think that you're right. There are some times that we have been more active in that space. I will say also that in terms of listing the amicus briefs that have been filed, I don't know that the website is exactly up to date. And actually, I just talked to somebody about that, making sure that we post more of them. But the really important thing is that there is a process, that the Commission goes through. And because, as I mentioned earlier, in a case in which there's a consideration of the Commission appearing as an amicus, that is by definition a case in which the Commission is not a party. So the Commission itself, the commissioners have not had an opportunity to sort of weigh in on the case through that very long and detailed process that I was just talking about and that Gerbir was referring to in our own enforcement actions. And so what happens is, it can happen in a variety of ways. I mean, parties can come to us and say, hey, we have an important securities law issue in a case, and it's a private case, but we think it would be helpful to have the Commission's perspective shared with the court on this case. And that's often true, and sometimes can make a big difference. But because of our process, which involves meeting with both sides in a case, hearing from them about what position should the Commission take, should the Commission weigh in or not, and then ultimately what our staff has to do, which is to research and come up with its own view on what the right answer is and whether it's a good case for the Commission to get involved in. And then the Commission itself needs to deliberate on it and make a judgment about whether it will authorize the filing of a brief, and if so, what position. That takes a lot of time. I know people sometimes think, well, now I've filed my brief, so let's see, it would be great to have the Commission come in support of our position. Typically, it's impossible to do it in that time frame to accomplish all the stuff that I was just talking about. So the sort of practice point for people who are involved in litigation of this sort, a private matter that involves a significant issue of securities law, is contact us soon. Don't wait until after your brief is filed, because what happens, and that we've gotten, there is the method that Dixie referred to on the website, and I get those. I get those emails saying, we think this is an important case, this is a critical issue, we'd love to have the Commission weigh in, but our brief would have to be filed within 2 weeks. It's just, we can't do that. And there are some issues I think we probably would have weighed in on if there had been an adequate time to get involved in it. So that's just a process point about it. And we're always interested, and I always talk to the people when they make those submissions, but unfortunately there are a lot of times where I just have to say, as a practical matter, we just can't do it.
So get your requests in early if that's what you want to do. A couple of issues I want to make sure we pull through as we're finishing our time here. I knew it would go fast. One is on Signal and the off-channel communications. I have been surprised at how, number one, how many people are using those applications, and number two, how many people are using them for business and not to avoid other situations, but because they're convenient. And so I think I am old enough that it feels suspicious for anybody not to want to write old-fashioned letters. You know, I'm all the way back before email. But there is a lot of activity out there on those mediums, and it's a pain to produce from Signal. So if you do have people using Signal and some of these other systems, number one, find out if they are, and number two, think about whether they're your business records, whether you have the ability to get those records. Sometimes companies don't have rights to the individual communications that people are engaging in. So it's a challenge when we're doing productions. One of the issues that you have spoken up a lot about in other contexts, Gurbir, is clawbacks. And we know the SEC just adopted rules requiring exchanges to adopt rules about clawbacks by their listed companies. And that's obtaining back from executive officers and others who received incentive compensation, getting that back to the company if ultimately it's deemed they weren't entitled to it, essentially. That's the theory behind it, anyway. Can you tell a little bit about what you've been doing in your program under the existing authority before those exchanges adopt those new rules?
Sure. We use SOX 304 clawbacks with respect to CEOs and CFOs to claw back incentive-based and other compensation for a period of time after a misstatement for which a restatement was required. I think the practice previously for a time had been to limit that clawback to what was sometimes referred to as the fraud delta, which was the amount that compensation may have been inflated upward by the misstatement, and to leave it at that delta. But the rule itself allows you to claw back the entire amount, not just the excess amount or that fraud delta. And so in recent orders and recent resolutions, and also in litigated matters, we are seeking the entire amount. And the reason for that is the rule was designed to allow us to seek that entire amount. The rule was designed to promote better behavior at large institutions to make sure that CFOs and CEOs were engaged in these processes, investing in compliance, making sure that things were being done the right way. And so the Commission is using that rule as it was designed. The new rules don't necessarily overlap with the existing rules. They talk about excess compensation. And so, we're not seeking, with respect to the new rules, to duplicate recovery, but if we're allowed to get more using 304, we're entitled to it, and that's what you'll see happening, and that's what you've seen in recent Commission orders.
And then where does that money go?
It goes back to the companies.
Yeah, it's an interesting dynamic when you're in the middle of an enforcement investigation, because the company itself may not currently have clawback procedures or an ability to get that money back, but the SEC can get it back for you in some situations. So it's an interesting dynamic. It also, as I understand it, and Michael, I'm sure you were involved in some of this litigation, it doesn't matter whether the CEO, under SOX, it doesn't matter whether the CEO or the CFO, who are the ones that are relevant under the SOX provision, whether they were at fault.
That's true, yeah, and as Gurbir was saying, I mean, the statute is crafted in that way specifically. The notion is simply that the set of circumstances didn't actually exist under which the compensation was paid. And so it's, on that theory, that's true whether or not there was wrongdoing on the part of the recipient.
Which is really scary for executives years later to realize that, many, many millions of dollars often they shouldn't have gotten in the first place, according to the SEC, so it has to be clawed back.
That's right.
So, gatekeepers. some people don't like that term, and other people view it as kind of an honorary badge that we're part of the team to take care of compliance everywhere. But I think when people don't like the term, it's when it's used as part of a phrase, gatekeeper liability. And the universe of gatekeepers includes, I think, many of the people in this room, counsel to companies outside of the company, counsel to companies inside the company, accountants, auditors, all sorts of different folks who aren't in the government, but are trying to help everybody get it right. Can you talk a little bit about gatekeeper liability? And I know you brought a big case against an audit firm. Not really its gatekeeper duty that was breached, it was really the ethics components, but can you talk a little bit about that case?
Sure, and I should have mentioned at the top about priorities. Gatekeeper liability, gatekeeper accountability is a priority for us, and I think when I look at it, we're not trying to play gotcha with the CCO who did everything possible on their end, had policies and procedures in place. The cases that we're bringing are the ones that clearly cross the line when the gatekeepers are involved in the misconduct, where there were no policies to begin with, where they just really stood down on their job. So I think we're not in a gray area. It's pretty clear in these cases, and in Ernst & Young, the matter that Dixie was alluding to, I would submit that these were gatekeepers at the gatekeeper who were cheating on, of all things, the ethics portion of the CPA exam, right? These are the people who are signing off on the financial statements for your issuer, for your clients and your companies. They were cheating on the ethics exam to the CPA exam, that portion of it. And so that's a big deal to us when you can't trust the gatekeepers at the gatekeeper. And so that was a $100 million resolution with really detailed undertakings requiring different levels of review and policies and procedures, compliance consultants, and then also another layer of compliance consultants to do a deep dive internally to work with the board in that case to see if there should be folks who should be disciplined and terminated or otherwise held accountable for their role there. The other part of that wasn't the first time that this particular entity engaged in this type of misconduct. They had done the same thing 10 years earlier in providing answers and answer keys to help facilitate their folks passing these exams. And they weren't the only ones in this particular industry that got caught doing this. KPMG, a number of years earlier, had a similar test cheating scandal. And so there were a number of incidents in the accounting space among the big audit firms, and that's why I think that resolution is so important to get out there with that message that we are going to hold these folks accountable, that this matters, and we need to get this right because, again, if you don't have confidence in audit professionals, it really compromises a lot of what you're trying to do and what we're trying to do.
There was a really interesting component in that resolution,
yep,
too, relating to one of those consultants. Part of the SEC's order was critical of the company for not promptly, in the SEC's view, reporting that a representation they had made, they learned that it wasn't correct. And the provision in the settlement relates to what the company now is required to do to go back and figure out how it could be that they were able to make a representation to the government that was false during an enforcement investigation. I guess it wasn't false at the time it was made, it just wasn't updated.
That's an artful way of saying that they lied to us during the course of the investigation. But the issue here was this investigation came on the heels of that KPMG investigation that I mentioned a moment ago, where they had a similar cheating scandal. And as is the case when we see risk in a particular space, we wanted to see if other audit firms had similar problems. And so we sent a request to a number of audit firms to include E&Y, and we said, hey, have you received any complaints internally about test cheating? Have people tried to report up similar issues at your firm in the wake of the E&Y matter. And you're right, there was a gray area there, maybe a separation of a day where a report had come into one part of the entity and somebody else sitting elsewhere reported up, oh, we don't have this problem, but then they got that information the next day after they came to us and said, we don't have a problem. I would submit to you, they had a duty to correct that if they were going to be truthful with us, while it might be technically right that they had a report on day one, on day two they made the representation, and on day three, the people who made the representation got the information clearly indicating to them that they had a problem. Then they did an internal investigation and then still didn't report to us, but instead went to the PCAOB knowing that we were looking at this very issue, right? So this is not hard. We just need to be straightforward. And again, it's not a game of gotcha, but we need to have this candor on both sides. I know Eric has spent the better part of yesterday to say, come in and talk to us. You could do the same thing with us. We're not here to ratchet up penalties unnecessarily. We have plenty of resolutions over the last 18 months since I've been there and working with the commission to put out there what we see as good cooperation, where people who have self-reported, done everything right, and have had zero penalty. People who may not have self-reported, but then started to cooperate with us, again, resulting in no penalty. So there's a lot of room here for us to work together, again, in this shared endeavor to make sure things are functioning better for all market participants and for investors more broadly.
And that consultant, one of the two consultants, is specifically authorized to go in and see privileged information. They structured it so that they can get to the bottom of what happened here and then evaluate how to report that out to the commission. Is that
report out and hold folks accountable too, but make recommendations to the board about whether there should be some accountability. So it's two levels of ICC's compliance consultants, one that's behind the privilege wall and one that's on the other side of the privilege wall that could report out to us, so they could have this back and forth, because a lot of things were hidden behind privilege, and we thought that was an effective way to address those issues.
And it was a settlement, so they agreed to do that. Really interesting if you haven't had a chance to look at the case. So we just have a couple more minutes. I knew we would get through things pretty quickly. And we haven't really talked very much about the appeals from trials, although we did cover the topic. We haven't talked about crypto much, although you did mention that it's a big priority issue for everyone. Are there any just last words that you'd like to share with the audience? And maybe Michael, we can start with you first, so Kabir can think about, because you've done a great job of telling us what's on your mind today.
Sure. Well, thank you again for the opportunity to come in. We really enjoy being able to present. And I do think that if there were a takeaway from this, it largely comes from what Kabir has already said, which is, that it's a cooperative relationship. We are only so many people at the commission. We do what we can do to help enforce the securities laws, but we really do count on, good folks who are working hard, like we know you are, to ensure that the entities that you're a part of do the same thing. And when you do confront difficulty, like in the context for me in particular, when you're involved in litigation, which raises major securities law issues, if you think we can be helpful, come in soon.
Great. Kabir?
Just to add to what Michael said, we want to work with each of you. We really do think that a cooperative, proactive compliance approach where we're working together is the best way to deliver, for investors and to execute on our mission. And that's going to require each of you, as I mentioned earlier in my remarks, to really get engaged in your business lines, get engaged with your clients, identify the risks, educate yourselves as to what we're looking at, where we're seeing risk, and then execute. We see a lot of folks fall short on that last piece, and I think the orders out there, the enforcement actions, give you enough ammunition to go back, to get the resources you need to do your jobs effectively, to work with your outside counsel, your inside counsel, to create a compliance system that actually works and results in better outcomes, in whether it's in an enforcement action or otherwise.
Thank you both very much for being here. We really appreciate it. And we are going to resume with the ethics session at 9:15. Thanks, everybody.
Thank you.